We're going to be reviewing the NAR Code of Ethics Standard of Procedure 1-16 or SOP 116 today. This has come up quite frequently in comments by Curtis Bullock, the attorney for the board, as well as general practice. I've seen issues about this on social media fora, as well as issues that have occurred right here in our own brokerage. So as we start, just a quick reminder, the NAR Code of Ethics are organized in 17 articles. Each of the articles is a general statement of expectations of behaviors by real estate agents or realtors, as we're commonly called. Each of these statements of expectations is what in professional speech is known as a normative statement. It is the statement of what the norm is, the highest standard of behavior. Each is then broken into standards of practice, also known as an SOP. These are statements of specific actions that realtors are expected to take in the course of their day-to-day activities as a real estate agent or realtor. These are more specific. These are really where the rubber hits the road. For an agent to bring an ethics violation complaint against another agent, they must first demonstrate that the agent violated one of the 17 articles. In order to provide evidence that the article or the expectation of behavior was violated, they then must show evidence that one or more of the standards of practice associated with that article were violated. In the case of today's video, we're going to be looking at Article 1, the requirements when representing a buyer, seller, landlord, or tenant, or other type of agents in order to promote the interests of their client. This is the first in order, and it's considered one of the most primary, in that we have this obligation as to how we treat buyers, sellers, landlords, tenants, clients, agents, realtors, basically every party to a transaction. We have a very high standard of honesty and integrity in the way that we approach our treatment of them. In fact, the Utah State Regulation R162 that regulates us states that we have a fiduciary responsibility of honesty to all parties. While honesty is kind of a large, broad term, this is then broken down into specific standards of practice. The standard of practice we're going to focus on today is Standard of Practice 1-16. Realtors shall not access or use or permit or enable others to access or use listed or managed property on terms or conditions other than those authorized by the owner or seller. We are obligated by our Code of Ethics that we are very conscientious about who accesses properties that we have access to, either as the agent representing a buyer or the agent representing a seller. We're going to go through some common, not so much misconceptions as common errors that are made, that are most commonly the reasons why ethics complaints are filed against agents in violation of SOP 116. The most common type of complaint is where an agent accesses a property outside of the time of access that has been granted by the property owner. We must remember that we are limited to our time of access to that property by any time that has been pre-approved and scheduled with the property owner. We must arrive on time and we must depart on time. We must stay within the parameters of the time that we have requested to walk through and have others have access to that property. The most common type of concern with this is arriving either excessively early to a property or excessively late. Most common, oftentimes, we get behind. We have 2 or 3 or 4 showings stacked up back to back. Our client unexpectedly spends extra time at one showing, and now we arrive after the time that our scheduled showing for this property is over, and yet we show the home anyway. We are now in violation of this aspect of SOP 116. We're also technically in trespass at that time under Utah trespass law. Our approved time to be available on the property and for others to have access to the property has now exceeded what the property owner has approved. In the event that our anticipated time of access changes, and let's be honest, it happens during the course of the day, we are responsible for communicating to the listing agent as soon as possible any changes in our time that we will be accessing the property, even if that occurs during the day of the anticipated showing. It's an ethical requirement. It's also simply a matter of good common practice to keep the other agent and their clients appraised of if we are running behind. If we're 5 or 10 minutes behind, it's still good to let them know we're running a little bit behind, but we are on our way. If we're going to be significantly behind and we need to adjust the time, then we need to communicate that, even if it is during the course of the day. Oftentimes we'll have clients change their minds overnight and decide not to go see a home, or they may even change their mind during the course of the day. We still need to communicate to the other parties that we will not be showing the property. We have individuals who are making their property available to us, oftentimes at great inconvenience to themselves, and we need to respect that as agents during the course of our showings. As an agent, we are responsible for all people who access the property at any time we are there. In the post-COVID world, we still continue to see listings that restrict the number of people that they are comfortable with in their property at a given time. While we may not see as often that it's restricted to 2 or 3 individuals in the property time, it still may include in the showing instructions that they are restricting how many people are allowed on the property during the time. The most common type of restriction for this is when using any of the scheduling programs or contacting the listing agent for a scheduling time when the instructions state that the seller does not allow overlapping showings. This makes it incumbent upon the showing agents to complete their showings on time, especially if there's another showing coming after them. It's become somewhat common that in the event of an overlapping showing, one group walks around the yard, another group walks inside the house. It is considered a violation of ethics and SOP 116 to stay in the home longer than you have been granted access to, particularly when that now restricts the number of people who can be in the home. We should also always be aware of any instructions regarding children accessing the home. Again, in the post-COVID world, this is still occasionally part of the instructions, but just as a general act, as a realtor showing a property, we need to be aware of children in the home and how they will be reacting to the home. Walking ahead of them through the home, especially in homes that may have toys or books or things that may be of interest to a child, we are responsible for making sure that the parents are keeping their children under control and they are not attempting to play with or access anything in the home. We are also responsible for any additional third-party vendors that we schedule for access to the home, including inspectors, appraisers, photographers, or other vendors who will be accessing the home. It is in our best interest as much as possible to be present at the time, either representing the buyer or the seller, to verify that those who are accessing the property do so in an appropriate and professional manner. We are responsible for anything that occurs in the home while they are there, if we have scheduled their access to the property. We also need to always be aware of any specific instructions that may be included in the showing instructions. For example, it still oftentimes shows that the seller is requesting that you either wear booties or take your shoes off in the home. In the winter season, this becomes much more of an issue as people walking through the home are frequently coming in from a wet environment outside. It's also a matter of simply showing respect for the other person's home to take shoes off or to wear booties, something that will cover the wet shoes as you walk through the home and protect the home. Instructions may also include to leave the lights turned on, leave doors open. Any types of specific instructions for that are very important that are followed. I personally had a situation showing a home where, as we walked through the front door, there was next to the door a picture of a very bright, bubbly, smiling young child in a wheelchair with a statement that the home was the home of an immunocompromised child, and that the sellers had requested that all individuals walking through the home wear booties or take their shoes off and use the hand sanitizer before they touch anything in the home in order to protect the immunocompromised child. We diligently followed through with that. That was the seller's request. One issue that oftentimes comes up is the presence of pets on the property. Many listing agents, myself included, as much as possible, try to make sure that pets are not in the home during the times of showing, especially dogs. Dogs can be very protective regardless of their native personality. However, that may not always be the option. It may not always be possible, and the owner may have to kennel an animal on the property. Do not interact with the animals without the seller's permission. It is very stressful for those animals while we're present in the home, and they may respond in ways that they would not normally respond. Another one that oftentimes comes up that I've seen in instructions is regarding cats, particularly do not let the cat out. So cats may be present in the home. It's also important to be aware if pets are present, if you have a client that has a pet allergy, that they need to be aware of that there is a pet present on the property, and that that may be a risk for them, and that may be a reason regarding whether or not the listing was scheduled for a showing to begin with. So it's always important for listing agents to make sure that the presence of pets on the property is clearly stated so that potential viewers of the home know what is occurring. New construction oftentimes has unique concerns regarding accessing the property written into the contract for new construction homes, particularly those that are actively under construction, oftentimes have very specific statements regarding steps for accessing the property by the buyer while the home is still under construction, typically restricted to times with where the property can be accessed in the presence or with the escort of a building supervisor or construction supervisor. If the home is not available at all because of what is going on during construction, then potential after hours when there are not workers on site, but to constantly be aware that you cannot simply walk into a construction zone and have things go the way that you really want them to go. It is very much a safety issue for the buyer as well as those who are involved in the construction process. In the modern world, it is not uncommon to do video or photography showings of properties. Where I work with VA clients all over the world, it's not uncommon for me to contact an agent, request a showing, and state at the time I'm requesting the showing that I will be using videography for the showing. Now, because of time differences, it doesn't always work that we can use something like go on and do a live showing through FaceTime or other social media that allows us to be live during the showing, and consequently a video may be required to be shot. In the event that that is occurring, be very explicit to the listing agent that you will be recording a video of the property, but the only individuals that will have access to the video are yourself and your clients. In those situations where I have to do a video, I've learned it works best to use 2 to 2.5 minute clips that I then email as attachments to the recipients, my buyers, that then become converted into most typically a Google Drive link that I share with them, so they only have access to that. We have an obligation to restrict who has access to that because it is essentially a type of showing that others could be seeing. Some sellers may actually request written permission. If that's the case, an email to the agent is good. Most of the time, I've been able to simply get permission from the listing agent by stating to them that that is what's occurring. But we do need to stick with the approved purpose and the approved audience. Do not go take pictures of a home without permission and then post them on social media. It's not your listing, it's not your property, and it has occurred where agents have posted images of a home they've just shown or that they have accessed without the seller's written permission, only to have the seller then find those images on social media and file a complaint that an individual is now posting images on social media advertising the property without their permission. A final reminder here is a reminder that many homes now have some type of video doorbell or security system in the property. If there's a video doorbell, or if you see security cameras, or even if you just see a Nest digital thermostat in the home, assume you're being recorded. In fact, just plain assume most homes you're being recorded as you walk through the home. Be very aware of that and how you act and how your clients act walking through the home. A client who treats the home respectfully and speaks positively of the home will have a much greater possibility of entering into a positive purchase contract than someone who speaks negatively of the home, acts inappropriately in the property, who speaks derogatorily of the home. Absolutely do not speak derogatorily of a property while on the property. Assume you're being recorded, and your derogatory comments about a property while in the presence of a seller may be terms for stating you violated 116 and that you were not honest about the property, you spoke negatively about the property, or spoke negatively about the agent, all of which are violations of the standard 13, but of all of which are considered unethical. It is not considered unethical to point out what may be considered material defects or in the property while walking through. As a general practice, if you're going to speak about the home, do so away from the front porch, away from the property itself, where you can have that very candid conversation about a property with your client, but away from a situation where it can be recorded. My worst situation with this was a client who, as we walked through the home, gushed over and over and over about how this was the home. She had to have this home. She had found her home. This was the home she had to have. And I knew that it was a reach home for them at the very maximum of what they were approved for. And they would be requesting seller concessions, making it a very difficult offer to try to compete with in a multiple offer setting. And she had just gushed all the way through the home, leaving me absolutely no way as an agent to try to negotiate on their behalf, because the seller knew that she was in love with the home. The same can occur if you walk through and speak derogatorily of a home. And in one really odd situation, that did in fact result in an agent facing very strict standard violation. An agent showing the home opened the fridge, took a beer out of the fridge, popped it open, and commenced to drink the beer standing in the kitchen while his clients walked through the home unescorted, all while being recorded by an in-home camera tied to the digital system, tied to the digital camera on the front door. All of them were integrated together, and the seller was able to not only see this happen in real time, but also then saved the video for a complaint. Really, ultimately, our goal here is to make sure that you and your clients have positive experiences as a listing agent, positive experiences as potential buyers walking through a home. As a buyer's agent, positive experience with your buyers, having an opportunity to access the home, but making sure that all is done in a setting where the home is respected, the seller's rights of privacy are respected, and that we act in a most professional manner possible.